Framing of charges. First of all, what is the purpose of a charge? Under the code of CrPC, an accused should be informed of the offense of which he is charged. The basic purpose of the charge is to let the accused know of the offense he is charged with so that he can prepare for his defense. Be informed of the charge against him at the very beginning. Every accused has the right to know what the prosecution has against the underlying principle of the criminal law is informing the accused of the charge against him is to provide an equal opportunity to each and every individual to prepare his defense and avail justice. It must be noted in case of serious offences, the statute requires to be reduced to writing precisely and clearly, must be read to the accused and explained clearly with precision and clarity. This was said in the case of the Supreme Court, VC Shukla versus State. Charges, types of charges. How many types of charges frame we see here? First of all, we see the question of framing the charge against the accused arises only when the accused is not entitled to discharge under section 227 and 239 of the CRPC. If we want to see section 277, the 277 deals with the discharge of the accused in sessions cases. It states that if the judge, after hearing the accused, prosecution and evidence records, the judge can consider the documents submitted herein, consider that there is no sufficient ground to protect against the accused, then the judge shall frame the charge and noted the charges in writing. Record the reasons also. The accused, it after considering the police report, the documents and submitted under everything. Section 173 of the code comes to the conclusion that charge against the accused is groundless. The magistrate shall give the opportunity of being heard the accused and prosecution and record the reasons in writing. There are some types of cases. Among those, the charges are framed like this way. Number one, sessions cases under section 228 of the code. Number two, warrant cases under section 240. Policers instituted the case, report under 240 of the CrPC. And number three, warrant cases Warrant cases instituted by the police. Otherwise, on police report under section 246 1, what to say about the sessions cases. Under section 228, the code deals with the framing of charges. In case of a trial before the court of sessions, in such a case, the charge is framed against the accused only when the accused is not entitled to discharge. Under section 277 of the code. Under section 228 of the code states like this. If the judge opinion the accused has committed an offense, at the time there are two ways there is. Not triable by the court of sessions, the judge may frame the charge against the accused and may order to transfer the case to the chief judicial magistrate or principal judicial magistrate or any other judicial magistrate of the first class, and may order the accused. He may order the accused in such cases. The date is required and sufficient time, and a date should be mentioned to attend before the honorable magistrate. And in the same way, procedure for a trial of a warrant cases instituted on a police report. In the same way, accordance with number 2, if there is exclusively a trial by the court of sessions, judge shall frame the charges against the accused, of which the charge shall be read and explained to the accused clearly, and whether he pleads guilty or not. Judge may ask as the accused the charges which and claims to be a tried. Like that way, the judge shall frame the charges against the accused. Suppose if there is a warrant cases instituted on a police report instituted by the police, warrant cases. At the time, section 240, the code deals with the framing of charges in case of the cases tried by the magistrate on a police report. It states like this way. Magistrate considered the examination and the hearing of the opinion of the prosecution, and sufficient grounds there is to presuming the accused has committed an offense. Triable under the section 240, the magistrate is competent to try and is of opinion adequately punished by the judge. The judge shall frame the charges and writing again. Suppose the warrant case is instituted otherwise on a police report. What happened? Section 246 of the CrPC states like when a warrant case otherwise than in the police report, the accused is brought before the court, before the magistrate, and magistrate upon the examination and the hearing is of the opinion that there are sufficient grounds to presume that the accused has committed of an offence. Then the magistrate shall frame the charge against the accused in writing. In all above the cases, when the charge is framed against the accused, it is important the said charge is read and explained to the accused clearly and precisely and accurately. It shall also be important to ask the accused whether he pleads guilty or not. And again, the judge shall ask the accused, there is the proper defense to the accused or not. And like that way, the judge shall ask and clearly explains all those things about accused offence. These are the three types of cases to frame the charges. One is under 228 of 8 in sections cases. Number 2, 240 police acts instituted on warrant cases. 246 police is instituted otherwise on warrant cases. Like this way, 246 police is instituted otherwise on warrant cases. Like this way, three types of ways. Judge shall frame the charges against the accused.